statutes. The present tense includes the past, present, future, the present, and the past, the present. Masculine gender includes the feminine and neuter. The plaintiffs and defendants both have the right to make their own visual and audio recordings of the proceedings of this court. I would never change that, no matter what you're doing. Always make sure that you have the right to create your own audio and visual recordings of your own proceedings of your own court. That way, you don't have to pay the filthy transcribist $500 for your own damn recordings. Record it and then have one of your friends transcribe it for $100 if you want to, whatever. And then all I have to do at the end is say, yes, under penalty of perjury, this is what was said in this hearing, right? Done. And I'm not going to go through the rest of this, but you get the point. So this is where you lay out your rules of your court, right? And so there's a lot of other things in here. Treatise versus Pagliaro is extremely important. This says, statements, quote, statements of counsel in brief or in argument are not facts before the court and are therefore insufficient for a motion to dismiss or for summary judgment. What does that mean? It means if the attorney, any attorney, doesn't matter, says anything in court that it cannot be considered a fact and is insufficient for a motion to dismiss or for summary judgment. So if the attorney in there says, Your Honor, so-and-so did such and such, or Your Honor, this is that and that's this. Objection, Your Honor. Treatise versus Pagliaro. Right? That's it. So it's the point that that one crushes anything that the attorneys are trying to do when they have no first-hand knowledge of anything because, like it says, are not facts before the court. So that's that. That's your rules and whatnot. Sealing of the court records. The court has the inherent power to seal materials submitted to it. So if you want to seal stuff, this just gives you the capacity to do so. Controlling terms and definitions. This you can alter however you want to, but I made it Bouvier's. All words and documents filed with this court of record or stated in open court or in deposition are as the plaintiff in this court of record understands them. You got a question, Judge? You don't understand something? Ask me. You don't get to determine it for yourself, and neither does that filthy attorney sitting over there. You ask me what it means, and I'll tell you. And if I don't have an answer for you immediately, fine, I'll tell you next week. Because you can't push me any farther than any faster than I want to go in my own court. But it's every word that you have in here is how you understand it, not them. That's extremely important to put in here. And then gets into sovereignty rights. I'm not going to read all these, but they're just fun things proving that we're all sovereign. Again, the red stuff is stuff I haven't shepherdized, so make sure you check it. And as you can see, I have quite a few of those. Reservation of sovereignty. This is an aspect that even if I signed a contract, it doesn't mean that I'm not sovereign, or you can't take away my sovereignty because I signed a contract. Bill talks about that case. Republican government, what it is, meaning that's where I'm at. I'm not in a filthy democracy. Effective congressional consent. This has more to do with federal law, so you don't really have to worry about it if you're only in state court. And then citizen of the United States. So this is where I put in to make sure that if they ever question what you're doing as far as I'm a member of the peerage and they're not, this is all you have to go through, right? So this is what a citizen of the United States is. Again, a citizen of the United States is a citizen of the federal government. Look at that. Now, again, I didn't shepherdize this, but I know that's right anyway. Taxpayers are not de jure state citizens. That would be interesting for any IRS case, right? In fact, you know what? Dig, I'll put that in chat just for you because you're gonna want that one. Okay. The term citizen in the United States is analogous to the term subject in common law. The change of phrase has resulted from the change in government. Right. So, I didn't see your question, Chief. Sorry, I was bouncing around. Couldn't a decision of a court of record be reviewed through an appeal to a grand jury? No, it's not called an appeal to a grand jury. Yes, it can be, but that's not what you'd call it. A grand jury can retry any case it wants to before the full grand jury. And how you do that is called something, you come upon it, it's called a writ of attaint. You can file a writ of attaint to any grand jury, well, common law, 25-member grand jury of the peerage. You can file a writ of attaint to a grand jury, and that grand jury can retry the entire case. That doesn't matter even if it wasn't a court of record. They can still do it because guess what? They are above even a sovereign's court of record. It's not called an appeal, though. It's specifically called a writ of attaint. Yeah, just look up writ of attaint. And here's the thing. Search the common law treatises for the term. See if you can find writ of attaint in any of the common law treatises that I gave you guys, and you'll see how it works. And if not, specifically try to go out and find it and then pull out all the information you possibly can about it. Anyway, little side history to the what a writ of attaint is, since we brought it up. A writ of attaint is something that was used multiple times in early colonial during the colonies. It was the thing that was the bane of England, because they don't talk a lot about in history, because they do not want anybody to know that you can do this. But it was discussed back and forth from a admiralty judge to the king. There was a specific letter, and Bill Thornton talks about this. It's probably in the audios that you guys have for download. And basically what this admiralty law judge wrote to the king, said, these colonists during the night destroy the king's property and ransack this, that, and the next thing. And during the day, they acquit everybody in their grand juries. So he was complaining that he couldn't enforce the king's law because everybody in America was a lawyer. They knew their power. So can we still do this today? Absolutely. Why is nobody doing it? Because they don't know it. They have no idea. They don't know it exists. If everybody knew it, I'm sure everybody would be doing it. I'm sure everybody at least has 25 friends that would come to their aid had they been put into a filthy jail for 3 years. I mean, I know I would. So honestly, that's really all it comes down to, is a writ of attaint. So to go find it, we probably should put it in the law of the case if we wanted to be specific as to the only way to overcome, or to come over the top of, I should say, the judgment of our courts of record. Say, only by a writ of attaint shall matters of this court of record be re-examined, and then only according to the course of the common law. Something like that. You could write it. Unless the defendant can prove he is not a citizen of the United States, the IRS has the right to inquire and determine a tax liability. Well, bam. How do you prove you're not something? You put it into an affidavit. Done deal. I am one of the people of Michigan. I'm not, therefore, a citizen of the United States, for I am not subject to the jurisdiction of Congress, as per the 14th Amendment. Signed, sealed, delivered. There. You just took care of that whole case holding. One fell swoop. Anyway, I'm not going to read all this. These are all the aspects of United States citizen. They just keep going because I have a lot of them, and I collected somebody else's case law on it, which is why the vast majority of this is read. United States, the corporation, obviously. Habeas corpus, this is everything to do with habeas corpus. I won't go through it, but you guys, it's all in there. Everything from amjur to a lot of things. There was one interesting thing in here. The writ of habeas corpus cum causa, sometimes habeas corpus ad factiendum et recipendum, is another of the forms, and a rather unusual form, of the writ of habeas corpus that existed under English law. It issued where a person was sued in some inferior jurisdiction and wanted to remove the action to a superior court. The writ of habeas corpus cum causa, whose existence has been recognized by at least one early American court, is said to be grantable of common right, without any motion in court, and to instantaneously supersede all proceedings in the court below. Does that sound powerful? Sure does to me. And notice the N things. So it's N22, N23, and N24. These are so you'd scroll down here to N23. I think I put them in here. Yeah. So you'd go down and hit the parts of this anyway. And I believe I took this I think I took this directly out of amjur. Yeah, I think I took this part out of amjur, the habeas corpus cum causa. So again, you want to get somebody out of jail, do the habeas corpus, or get yourself out. Do the habeas corpus cum causa, do it in a superior court, and then rule on the habeas corpus in the superior court. That's going to piss them off. But anyway, so another fun thing you can do. So anyway, this is all habeas corpus stuff. I'll just, okay, writs in general, just some stuff on writs here. These are two things that I just righted myself. The following officers are authorized to help enforce the writs and judgments of this court: lawfully elected sheriffs, constables, United States marshals, coroners, marshals of this court of record, and members of the peerage who wish to help in a lawful manner according to the commands, the writs, and judgments of this court. Yeah, I should probably put in, yeah, you could put in militia. Yeah, you could have militia in here. All right, just put it in right here, state militia, comma. There, see? Great, now you can call the whole militia on them. And that's as easy as this is, honestly. I mean, you're writing your own law, figure it out, right? You want something in there? Put it in there. Want something taken out? Take it out. This is the law of the case I'm giving you guys. You can mess with it, change it, alter it, however the hell you want. It's your court. When a writ is delivered or final judgment, summary or otherwise, it is to be enforced, or a fine for contempt is to be collected, or someone is to be imprisoned for contempt. It is the duty of the officers of this court to execute the commands emanating from this court and instruments thereof promptly and vigorously. That's just telling everybody to do their job. A couple things about money, a couple things about contract, a couple things about consideration, some aspects about claim, what a public officer is, or what they're supposed to be doing. Right to travel stuff, this goes on for a while. This is all the right to use the roads however you see fit, so on and so forth. Again, a lot of stuff I haven't jeopardized, so pay attention and check it yourself. Jurisdiction. Okay. Does a court have jurisdiction or does it not have jurisdiction? So on and so forth, right? So we have no more right to decline the existence of jurisdiction which is given than to usurp that which is not given. The one or the other would be treason to the Constitution. Now, I've never checked that one, but I always thought, wow, that's a heavy punishment for taking jurisdiction. So anyway, again, things in red I haven't checked, so make sure to jeopardize them. But as you can see, I have a lot of them for jurisdiction. I've been collecting for a while. Due process, these are fun. By the way, this is Heath Boyd, the one I was talking about the other day, where it talks about that they have to take you directly before a magistrate immediately upon arrest, not to jail, meaning you don't get to punish him. You have to take him directly before a magistrate. So when this happens, when they don't do that, you can bring up Heath Boyd, which is a Texas case. And the other one, Gerstein Pugh, is it's a Florida case. Anyway, these are two really, really good ones about having to take someone directly before a magistrate upon arrest. And if they don't do so, then they've lost the entire capacity to even charge you, period. Totally, because of these two cases. And there's a lot more than just this too. But anyway, when the stakes are this high, the detached judgment of a neutral magistrate, doesn't say judge, is essential if the Fourth Amendment is to furnish meaningful protection from unfounded interference with liberty. Accordingly, we hold that the Fourth Amendment requires a judicial determination of probable cause as a prerequisite to extended restraint of liberty following arrest. What is extended restraint of liberty? Putting you in jail. So if they take you straight to jail, bam, they just went against Gerstein Pugh. And they also went against Heath Boyd. This I'm not going to explain because it's a bit longer, but it's basically the same thing. It says exactly the same stuff. And Heath Boyd was an aspect that the magistrate did take him, or the cop did take him directly before magistrate, but the magistrate was, I think it was 30 miles farther away than a magistrate that he could have taken him to, being 30 miles closer. And because of that, and it said, yet Boyd offers no reason why he did not take Heath before that official, right? Because he didn't even take him one to the closest and most accessible, he won the suit, because that's what it says. It doesn't say whichever one you want to take me to. It means the nearest and most accessible, period. And I don't give a goddamn if it's 4 o'clock in the morning. Doesn't matter. That's why New York has night court. That's why Chicago has night court. Because you can't deny that, okay? You have to, doesn't matter what time of day it is, and if it's out in the rural countryside, you got to tell me where the judge lives. Tell me where the magistrate lives. You can go knock on his door. In fact, in rural places like Iowa, some folks, old folks, have told me about when they were young that the cop took them directly to the magistrate's house, and the preliminary hearing was done over the kitchen table. Totally viable, as long as you're in front of a magistrate. But the second that they go and take you into a jail, that is an absolute due process violation. So anyway, not that this is a due process course, but it's important to know that, because you'll want to sue for that reason, and you'll win, because clearly there's plenty of case law about it. Okay, so that's that. Venue, this is all the aspects of venue, what is and what is not. Warrants, when you can do a warrant and when they have to enforce it, when they can't enforce it. Yeah, this one, I love this one. I'm just going to read this because I love the language in it. Quote, it is the duty of every person who is charged with the execution of process to explain what would otherwise be a trespass by showing his warrant and his official character. So what's the warrant? It's the piece of paper that warrants the action that has to come from a court. What is his official character? That's his badge and his funny looking costume and, saying I'm a court officer. If he choose to conceal these, he puts himself outside the protection they give him. That means you get shot in the head, moron. And becomes, in the eye of all to whom he refuses to state them, an aggravated trespasser. Right? So he's no different than a thief coming into your house. And he who withholds such information not only takes all the risk of being treated as an insolent trespasser, meaning I'll shoot you in the head, but is guilty of bringing odium on the law of which he is the unworthy minister. I love that one. Because that's exactly what they do. They become unworthy ministers of the law. They're no longer a law enforcement officer. They're a damn thief. Shoot them. And I swear to God, if every single cop knew this damn holding, none of them would be so stupid. But anyway, I really like that one. Because unworthy, I love that unworthy part. Is guilty of bringing odium on the law of which he is the unworthy minister. I just love that part. Anyway. Land rights. So we got stuff for land in here that you want. So if you can deal with land stuff. Fictitious name or address. This is really interesting because this actually comes right out of U.S. Code. Conspiracy against rights. Deprivation of rights. This is a slight tweak of Title 42 suit. I actually changed the language. Somebody said, you shouldn't do that. It looks just like the thing, but it's different. I said, I don't care. It's my law. I'll decree it how I want to. Abolishment of a state of emergency. This I wrote specifically just to get rid of the emergency. Now, in a certain funny way, is this lawful what I did? Yes. In another way, is anybody going to pay attention to it? I don't know. But I thought it was a fun thing that I wrote. So I basically abolished the state of emergency regarding my court of record. So anyway, some stuff from Illinois Bill of Rights. Obviously, exchange this out with your state. Well, you can keep Illinois if you want to. I mean, because you can decree the law to be whatever you want. So if you like something in Illinois, use Illinois. But make sure to use your constitution as well. Magna Carta stuff is in here, the important ones, not all of it. Maxims, again, the important maxims, not all of them. Seal. Now this is where I'm talking about the seal. The seal of the Superior Court of Record shall be the great seal of the house of whatever. This seal is the property of the paterfamilias of the house of whatever, or materfamilias if you're a female and you didn't come under a man's house, and his heirs or her heirs, and assigns forever. Any use of this seal without the express written consent of the paterfamilias of the house of Doe or his heirs and assigns in any form carries with it the penalty of death. Because guess what? That's exactly what it says in the seal notice, and I'm not going to change it for court. The seal of this court shall be affixed to instruments by the hand of the sovereign of this court or special master in good standing with this court, or drawing said seal onto said instruments or by crimping the instruments with the embossed seal of the court. Directly below, to the right of the word seal, is the image of the great seal of the house of Doe, crimped with embosser or drawn by hand, and is to be recognized as such by all who see it, regardless of minor changes in style from one hand to another, which is for people that have ridiculously elaborate seals that would be hard to draw, but at least they get it half right, who are authorized to draw and use it. So as long as you're authorized to draw it, you can slightly screw it up and it's still valid. So then you put your seal here. So just remember that. In the law of the case, go crimp a little gold sticker and stick it there, right? Or draw it out if it's super simple if you want to, whatever. Rules of procedure, writs. Now, I wrote this rule procedure, this writ procedure for writs for my own court out of a writ treatise. Okay, this is completely something that I created and wrote because I couldn't find any rules on writs. So I said, okay, I'm just going to go through the writ treatise and I'm going to write it out. Now, I'm not going to read all this, but it's basically all the things that have to do with a writ, how it's done, who can serve it, how it runs, the issuance, the endorsement, and then I give some examples, and so on and so forth. And the service and execution, the execution, the return, its contents, right? So I give a whole layout of the process of writs. And that's the last thing. I know that was long-winded, but it's important to understand the law of the case because the law of the case it's a major part of the whole of what you're doing. Do your law of the case correctly, and so it's correct, and you know what your law is. Let's get back to going through this. So sections of an action at law. So you got the law of the case, then you got the parties. Okay, what are you doing with your parties? You have to name what they are, and you have to name also their relationship or their status. So if you want to put somebody under the bus, say, at all times mentioned herein, plaintiff is and was one of the people of Illinois, domiciled on private land, County of Winnebago, State of Illinois. At all times mentioned herein, defendant was a resident of wherever and was a citizen of the United States. Right? You can say things like that. And just put them directly under the bus if you want to. It's fine. It's because it's not like it's untrue. So So you state the parties and add any other parties need be, and make sure to put them in the heading above. Obviously, way up top, up here, right? Can't have anybody down there that isn't in here. So make sure that's correct. Make sure they match up. Introduction. This is a short synopsis of the suit in general. So over here, it's called introduction and commencement for all actions and for the nature of action. So parties to the suit, and this is again part of it. So the parties to the suit, and if they sue or be sued in another right or in political capacity as executors, assigns, quietem, whatever, make sure you put that in there in this part, in the party part. So say at all times mentioned here, and defendant is the executor of the John Henry Peterson estate. So make sure that the titles and things that they are laid in here. This is the introduction and commencement. In this, you want to say how they were served or notified, the mode of which the defendant has been brought into court, and a brief recital of the form of action to proceed it. So this is here. This is an action at law to recover damages for breach of contract regarding the lease of property located at wherever. Plaintiff entered into a contract with defendant to lease property located at wherever. Defendant has a duty to lease property to plaintiff that is able to be lived in and does not contain a health risk to plaintiff and others. This was actually a paragraph that I did a suit for somebody where they took a year lease, and then it found out that there was black mold like in the place, like all over the place. It damn near killed the wife. They didn't have any other place to go at the time. So that's where this came from. Plaintiff paid to defendant whatever amount of money for a down payment on a lease for said property. Defendant failed to inform plaintiff that the said property was not livable due to black mold and whatever other garbage was in there. Plaintiff, when finding out said property contained an amount of black mold, unsafe for living conditions, plaintiff demanded said down payment back and demanded rescission of the contract based on fraud. Right. So that's how you do that. You'd give a introduction as to what you're doing, why you're doing it, and who the morons are. Then you do your commencement, or also called, you can just call it a statement of cause. Either way, you can kind of say it either way. But, sorry, the commencement little part, this is just a tiny little part. It says, this is an action at law in a court of record wherein plaintiff seeks to recover damages from the defendant for the foregoing injuries, stated here, breach of contract, fraud, unfair business practices, and whatever the hell else he did. Right, so that's your commencement. Statement of the cause, this is where you get into, and this is, in all actions, the requisite of certainty must be observed. These will necessarily vary according to the circumstance of each particular case, obviously, and the form of action, whether in assumpsit, debt, covenant, debt new, case, trover, replevin, or trespass, or ejectment, or account. There's a lot of things I didn't put in there, but anyway, these are all common law actions, of which I have a list that we'll go over later. So this is how you do your statement of the cause. So I said go to the bottom of this template and read and understand the definitions and parts of a declaration at law before you start to fill out any of this template. This is basically what this is. I think I copied and pasted this in the bottom of this. Oh, I just gave the definition of Bouvier's of what has to be in a declaration. Okay. Okay, and here's all the causes, the common law action. So these are the different actions. Trespass on the case, trover, ejectment, debt new, replevin, debt, covenant. By the way, covenant, this is something you guys can do after you have your doc set done. Because if they break your doc set, it's not just an action of account or an action of debt because they owe you. You could do an action of covenant because the action of covenant lies for the recovery of damages for breach of a covenant. That is a promise under seal, whether the damages are liquidated or unliquidated. When the damages are unliquidated, it is the only proper form of action. So get that. When you start signing and sealing things, you're going to be doing a lot of actions of covenant. So you should look up and see what they are because they're more powerful than just an action of account dealing with a simple contract. Okay? That's why the seal is so important. Anyway, I'm not going to get all these, but there's a list of the cause of action. So anyway, in your statement of cause and in your commencement, this is what you'd be writing out. So statement of the cause comes now. John Henry, House of Doe, who is at all times mentioned in the following declaration and actions at law, one of the people of Illinois. An American citizen, lawfully domiciled in Illinois, state, having been found to be living, having come to, I say come to / of full age, but it doesn't matter, and competent to give testimony, hereinafter plaintiff. And you can extend that out as much as you want to. Obviously, you could, if you really wanted to, you could take the first paragraph of the KW from the doc set and replace this with all of the rest of the things and statuses that are in the KW if you wanted to. And then say, instead of hereinafter claimant, you'd say hereinafter plaintiff. And in this court of record, so that's where we are, right? That's our court. Hereinafter Superior Court sues Jackass Johnson, a citizen of the United States and resident of the state of Illinois, hereinafter defendant, in an action of trespass on the case, and whatever other actions you do, you put in here, and demands he answer plaintiff in the following counts to wit. Then you do your, set your statement of cause, and then you pick, obviously you're picking your cause of action, which is one of these things, which we just went through. So I'll just skip down. And here's the thing, in your causes of action, in the statement of cause, which I didn't put in here, so you don't just go straight to conclusion, but you're in your cause of action, what you're putting in is the facts of what happened in the action. Okay, so this is where you list all the facts that are important to state regarding your suit and nothing more. No statements that try to prove a negative, i.e. like, I did not do, or I am not such and such. You only state things that can be proved. I am one of the people of Illinois. Only state what you can prove and make claims as to what you are as your own status, i.e. one of the people of Wisconsin, so lawful heir to your own estate, and so on and so forth. Also, make it a timeline, meaning first fact first, second fact second, and so on. You need all your facts to read like a story, because this is the place where you tell your story, is in the facts of the case, in your the facts of your cause of action, in your declaration. So this is the facts of the declaration. Plaintiff on such and such date did so and so. Defendant on such and such date did so and so. This is where you give the entire timeline of events that have taken place regarding the contract. And again, this was because I was giving this guy a template for his black mold problem. Regarding the contract, lease, the finding of the problem, notice is given regarding said, and the actions of the defendants. Be sure to add the exhibits into the case and label them correctly, like so, number 11, so on and so forth. On such and such date, plaintiff entered into a contract to lease the property located at wherever. See Exhibit A, lease contract, which is incorporated by references if fully stated herein. That is a valid way to state a fact. So you have facts and you have evidence. And so you have all your facts here, and then you have your, which is the causes. That's the aspect of the causes. So you, like I said, I'm just going to flip to that. So you pick your cause of action, done. And you state all your facts, because you already have your law up top. So you got your law up top, your jurisdiction, your venue, your facts, then your conclusion. And your conclusion is, in personal and mixed actions, the declaration should conclude to the damages of the plaintiff. Unless in serifacious and penal actions at the suit of a common informer, where you are owed damages for the injury caused and why the defendant should not have caused those injuries. So basically in the conclusion, what you do is you connect in a conclusion way the facts, whatever the facts are, and what you have in the law of the case. So you put the two and two together. So in the conclusion, this is where you put together the facts and the law that you have decreed and make statements of conclusion and because statements, right? So because defendant lied about whatever, he is a prick and therefore owes plaintiff damages in the amount of whatever. Because of the concealment of material facts regarding the presence of black mold in the property by the defendant is guilty of fraud and is a prick and should not be allowed to continue to be a prick. And this court should award plaintiff damages for the injuries caused by said prick. So you get the point. I was just being silly with that guy to make him laugh a little bit. So anyway, you just state it out like that as to the who, what, when, where, why, and how. And actually, you know what? That's an aspect of the trivium. And I have free classes up on the trivium, so I'm not going to go through it. But the point is, in all court cases, you have who, what, where, when, not why. Who, what, when, where, not why, and how. Those are the things that you're putting into your court case. And the reason it's not why is because you can't determine what their reason for doing something was. You can say that they had a motive to do something, but that's not saying why. Putting a motive is not exactly the same thing as saying why they did something. So avoid statements of fact like, so-and-so did something because I screwed his girlfriend. That's not a fact that, one, you can prove because it's a state of mind and it's his mind, not yours. And two, it's just an ad hominem anyway. Get your conclusion by connecting the two things together. And here's the thing. You can read a lot of conclusions. I think, honestly, yeah, let me check in the disc here. I'll go through the counterclaim and the DNC lawsuit. Anyway, so it'll be the next two things anyway, so I won't bother to stop here and do a stop and start. So we'll go through the conclusions and you'll get a better idea if you have any problem right now thinking about what that is. when we go through those two things. So, okay, so that's that. So you do the conclusion. The profert and the pledges. So pledge, this is where you pledge to prosecute the suit that you bring against the other until it is concluded. So the plaintiff in common pledges to prosecute defendant at law in this court of record until this matter and action are concluded, justice is rendered, and damages have been collected, or however the hell you want to say that. But that's just a basic one. And then demand for relief and judgment. Now, this is where you demand relief. So you profert to say, yep, I'm going to do this. The profert in an action of the suit of an executor or administrator immediately after conclusion of the damages and before the pledges, a profert of the letters testimony or letters administration should be made. So if you're doing any suit on behalf of someone or something else, like your own estate, you put the profert is where you put your executor appointment. You say that your executor appointment is filed at such and such county recorder, and you say that please see such and such, which is attachment A, B, C, or whatever it is. Such attachment and is incorporated by references so fully stated herein. Right. So you're telling and making the record to the court that yes, I have the right to do this because I'm the executor, and here's why. So that's the profert. And so you don't always have a profert, but it's important so you guys know about this. So, and then the pledge to prosecute, that's what I did read. And then demand for relief and judgment. Example, for the above stated cause of action, therefore, counter plaintiff brings a suit. For the above stated claims, counter plaintiff requires the foregoing relief. Wherefore, counter plaintiff requires relief and judgment against counter defendants as follows. Wherefore, counter plaintiff seeks judgment against counter defendant, and each of them as follows. However you want to, state that, or you can just state all those things and just leave them all in there. It doesn't matter. On all claims and causes of action, colon. Plaintiff wishes for final judgment again, and you wish, because when you're in your own court, your wish is the subject's command. And if you're in a superior court of record as a sovereign, guess what? The defendant is your subject. So just remember that. This isn't incorrect. This is actually correct. Plaintiff wishes for final judgment against defendant for actual damages, punitive damages, a reasonable attorney's fee, the cost of this action, and all other just and proper relief that the court sees fit to grant and order. Now, who's the court? You. So just remember that. Plaintiff wishes for declaratory judgment from this court of record that plaintiff holds allodial title to land to the exclusion of all others. This would be something that you'd put into this would be a finalization for an action of ejectment, which is where you're ejecting somebody off of a piece of land because you have allodial title to it, or just because it's not supposed to be there. For the total amount of taxes paid by mistake for all the years the plaintiff has been lawfully domiciled upon said land. That kind of goes along. This would be in like filing. This would be something you'd state for a suit against the county for property taxes. And for injuries caused by Winnebago County, plaintiff requires from defendant Winnebago County damages in the amount of $100,000 and 0 cents for unlawfully withholding the lawful title from the plaintiff, who is one of the people of Illinois, so on and so forth. Right. So you get the idea. So you write out what you're demanding. Make it reasonable. I don't want to see $500 billion. If you send me a case with something like that, you want me to proofread, I'm not even going to do it. I'm just going to go straight to what you're looking at for a demand. I'm going to say, you know what? You're crazy. Forget it. So be reasonable. As far as the judgments are concerned, the $300 million under the status docs and the KW are not unreasonable because it deals with the totality of your entire estate. It's every single thing of your estate. So, and the other fact is that when we've done, well, the people that have done the audits on the Bloomberg terminal for the fidelity bond that's connected to your birth certificate, most of them have come back around 300 million. So, but that's of course 300 million Federal Reserve notes, not 300 million rounds of silver. But nonetheless, that's why I just wanted to cover everything that I knew I would cover everything. The most I ever saw come back was really high, but I think it was because that he hadn't specifically asked for his specific part of the tranche. And a tranche is how they break up these bonds in either 8 or 12. And anyway, I don't want to get into all that. But the fact of the matter is that you're bonded for about $300 million. So, but just don't make it like some stupid thing like, oh, only 10 billion or whatever. That's not reasonable, and no one should ever grant that anyway. So that the court grant plaintiff relief and other such further relief as the court deems proper. Again, who's the court? Not the the magistrate's not the court. So guess who the court is? Well, you're a part of the court. Even you can't even call yourself the court. You are just a part of the court. So for costs of suit incurred, and then notice of default. The example: counter defendants have 30 days from service of process to answer counter plaintiff in all actions stated herein, or the court will rule in favor of counter plaintiff and award counter plaintiff all damages stated in relief required above by nil dissent default judgment against all the counter defendants. Now, nil dissent, what this means in Latin is that he says nothing. So basically says nothing default. So if you default them and they don't answer and they think that this suit is frivolous or whatever else, or they don't understand what's going on, or they don't think courts can be run outside of their corporate filth, well, then you warned them. You warned them that they're going to be default and how they're going to be defaulted. So it's not like you can't move through with it, which again is exactly what we did in Drew's case. So, and this pretty much says the same thing. And then the verification. And the verification is plaintiff has personal knowledge of the above stated facts and am competent to testify as to the truth of these facts if called as a witness. Plaintiff declares under penalty of perjury, under the laws of the United States of America, that the foregoing is true and correct, and that all the above actions at law and every declaration contained herein are executed on the land in the county of Winnebago, Republic of Illinois, on such and such, whatever. And then you put your sign here, and then put your seal here. Either here or here, doesn't really matter. Well, okay, it's all the way down there, but whatever. You can put it up top if you want. And then you do the teste mipso, John Henry House of Doe, and you can put the colon, and you can put the hyphen on the colon in there if you want, like this. Sovereign of the court, holder of the seal of this court, with said seal thereof hereunto affixed, attested by his own hand, who stands upon the land of the Republic of Illinois, this so and such day, 2016, signed and sealed. And then again, remove everything below this point. This is just for your information. So this is a back and forth of what's supposed to happen in the courts at law for the names of the things that go back and forth. Next thing is, again, just the things we just went over. This was the way the bill did it, the way the bill Thornton put it together. And then again, you have your various different actions, and then the defendant's common law defenses: peremptory plea, dilatory plea, traverse, denial, general issue, all that good stuff. And then this last section is from Bouvetier's Law Dictionary. This is the definition of a declaration. A declaration, pleading. A declaration is a specification in a methodical and logical form of the circumstances which constitute the plaintiff's cause of action. You file a cause of action in a superior court of record. Inside the cause of action, you have the declaration. Okay, just know that. In real actions, it is most properly called the count. In a personal one, the declaration. So in a real action is dealing with property, right? So real property. So real action is called the count. You have count 1, count 2, count 3, whatever. A real action is one that involves the rights of personal property like car, land, title, whatnot. Okay. The latter, however, is now the general term, being that commonly used when referring to real and personal actions without distinction, meaning it's just a declaration. So you can and should list your personal actions, torts, as count 1, count 2, count 3, and so on and so forth. And part 2, the declaration in an action at law answers to the bill in chancery, the libel of the civilians, and the allegations of the ecclesiastical courts. The declaration is within the action at law, not the other way around. Furthermore, answers means what they do in that jurisdiction. So you have a bill in chancery or in equity, right? You have a libel in the civilians, meaning Roman civil law court, even though a lot of the times they don't refer to it as a libel, but sometimes it is when it is actually for that, for what somebody said in print. And then in the ecclesiastical court, you have an allegation. So you allege such and such. I allege such and such. I allege such. Well, are you in ecclesiastical court? No. Then what are you doing alleging things? Anyway, that would be a funny question for an attorney. Number 3, it may be considered with reference first to those general requisites or qualities which govern the whole declaration, and 2, to its form, particular parts and requisites, which is why I gave you guys this cheat sheet here, okay? And then I'm not going to read the rest of the stuff, but it's the things that it's everything in here. It's all the things that I already went over. Okay. So the venue, the title, the venue, the commencement, the statement, the cause, the several counts, the conclusion, the proffered and pledges, it's everything that's in here. Okay. So I put it in here in a more nice format than how Bouvier had it when it came out. Okay. So that's the template of the cause of action. Now let's do the facts, evidence, and law, and let's also do, I'll pull up on this side to go along with that. Let's do the traffic court counterclaim, and let's do the DNC's suit against Russia. Just to cover this real quick here about the three different things that matter the most. So what are the three things that matter? Again, these definitions are from Bouvier's Law Dictionary. So facts, evidence, and I would put law in here, but if you went through Bouvier's Law Dictionary as to what law is, it would take up another 50 pages. So anyway, you want to learn the definition of law and everything regarding it, then get the totality of law class. I've covered everything in there about the different forms of law, all of it. So these are all the definitions for law in Bouvier's. That's only 16 pages. Okay, fine. I'm not going to read all this, obviously, but these are the three things that you need to always make sure are in your suit. Facts, where do they go, right? They go into the part of right after you say what action at law you're doing. So then you put all your facts in. And what's the evidence? The evidence is the stuff that gets attached to it. So when you say, see attachment A, which is incorporated by reference as though fully stated herein, if it's something written. If it's not something written, say, see exhibit A, the 22 caliber revolver that was recovered from the scene of the crime. Whatever the thing is, right? So that's the evidence. So a fact. In action, a thing done. So in action, a thing done is a fact. It is either simple or compound. A fact is simple when it expresses a purely material act unconnected with any moral qualification. For example, to say Peter went into his house is to express a simple fact. A compound fact contains the materiality of the act and the qualification which that act has in its, that's a connection, with morals and law. To say, then, that Peter has stolen a horse is to express a compound fact. For the fact of stealing expresses at that time the material fact of taking the horse, and of taking him with the guilty intention of depriving the owner of his property, and appropriating to it his own use, which is a violation of the law of property. Number 3, fact is also put in opposition to law. In every case which has to be tried, there are facts to be established, and the law which bears on those facts. Number 4, facts are also to be considered as material or immaterial. Material facts are those which are essential to the right of action or defense, and therefore of the substance of one or the other. These must always be proved, or immaterial, which are those not essential to the cause of action. These need not be proved. So, an immaterial fact doesn't mean it's like corporeal, that it's, in the air or something. An immaterial fact means it's not essential to the cause of action. Well, let's continue the Peter thing. So if Peter stole your horse, and you can say that whilst Peter stole the horse, he wore brown shoes. That's an immaterial fact. Who cares that the shoes are brown? It's irrelevant. There's an example. Now that he stole the horse on Tuesday last, that would be a material fact, because then you're getting to the time of which he did the act. And John over here, who's a neighbor to me, saw Peter steal said horse on same Tuesday last. That's also material fact. Facts are generally determined by a jury, but there are many facts which, being not the principal matters in issue, may be decided by the court, such as, for example, whether a subpoena has or has not been served, whether a party has or has not been summoned, so on and so forth, right? Things regarding process, basically. When you're dealing with facts of process, that's pretty much always with facts that go to the court. Then evidence. Evidence, that which demonstrates, makes clear, or ascertains the truth of the very fact or point in issue. So again, this is just where you're proving the thing with a document, or, like I said, the murder weapon, so on and so forth. And I'm not going to go all through this because I want to get through I want everybody to see what a proper counterclaim looks like. So I'm just going to kind of flip through this real quick because obviously it's pretty long. So that's a lot about evidence. Evidence circumstantial. The proof of facts which usually attain other facts sought to be proved, that which is not direct evidence. So evidence conclusive, evidence direct, evidence extringent, and then law. Obviously, we went through the law, but law in its most general and comprehensive sense, law signifies a rule of action, and this term is applied indiscriminately to all kinds of action, whether animate or inanimate, rational or irrational. In its more confined sense, law denotes the rule not of actions in general, but of human action or conduct. And don't worry about the civil Louisiana part. And then you have all the different kinds of law. So I gave it to you anyway. So you got law, civil, and common, all that good stuff. Criminal, foreign, partial, merchant, municipal, nations. Anyway, this is everything. All that stuff is everything that I covered in the totality of law class. So let's get into the traffic counterclaim. So this was the actual counterclaim. I believe this was the one that actually got filed, even though it wouldn't be in red. I did put the two different headings in here. So this was the original heading, plaintiff, state of Iowa, versus defendant. Res, I put res, so it's a thing. Res means thing. Defendant, thing. Philip Francis Honick, because that's a thing. It's an estate. Case number, and then so case number, and then, well, sorry. So that's the original suit, and then counter plaintiff, Philip Francis House of Honick. So I fill it out properly, not the thing, but a man versus counter defendant, state of Iowa corporation, whoever, a man, and Iowa District Court for Lee County, a corporation. Action trespass in the case, action of non-assumpsit, meaning I don't know you shit. Action of trespass, case, non-assumpsit, declaration, venue. All events described herein and all matters relating thereto occurred on unincorporated land in the county named or known as Lee, in the republic named or known as State of Iowa, and therefore all actions herein shall proceed by necessity according to the course of the common law in an action in a court of record in said county. See the law of the case, section so and so, blah 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 blah, which are all included by references of fully stated herein. Law of the case. Law of the case is fully agreed, yada yada. I'm not going to read this. Commencement for all actions. Here's the commencement, and this is what it looks like when you actually do it out. Philip Francis House of Honick was all times mentioned in the following declarations and actions at law. One of the people of Iowa, an American citizen, having come of full age, having been found to be living, confident to give the testimony stated herein, hereinafter, counter plaintiff. And in this court of record, hereinafter Superior Court, comes upon an action of trespass on the case, and non-assumption against so-and-so, which is a corporation and has the Dun & Bradstreet number of so-and-so. So I gave them the district court's Dun & Bradstreet number right in the commencement, just so that anybody wouldn't be confused as to what's going on here. Because, well, screw them. Hereinafter, inferior court. So we set up our superior court, we call them the inferior court. Hereinafter, singularly, counter-defendant and plural counter-defendants, and calls upon each of them to answer counter-plaintiff in these said actions in the Superior Court to wit, colon. Statement of the cause. Again, this looks a lot like the other one I said, but this is Iowa stuff. So we did that. See the law of the case, so that's in there. Count 1, trespass, specifics. Statement of fact. Counter-plaintiff now states the following facts regarding the events of September 9th in the year 2017 and after, and declares the same in these causes of action to the best of his knowledge and recollection to wit, colon. At all times mentioned herein, counter-plaintiff was and is one of the people of Iowa and an American citizen. 7. At all times mentioned herein, counter-plaintiff is and was domiciled on private land of Lee County, Republic of Iowa. At all times mentioned herein, counter-plaintiff has been found to be living and has come of full age. Counter-plaintiff is a free man. Counter-plaintiff is the donor, grantor, settler, sole lawful executor, and sole lawful heir of both the Philip Francis House's legal estate and the Philip F. Honick estate and trust. All the counter-defendants have been appointed as trustees of these things, right? That's the doc set, because Phil had his doc set done, so you can do that. You can do stuff like this when you have your doc set done. Sworn testimony entered into by the inferior court without objection by former narcotics officer Brian Paul House McFadden proves that the birth certificate of Philip Francis Honick was and is the res defendant in the inferior court case. Now, we did this in a different, this actually happened in a separate case, but the point is that we got someone on the stand who was a former narcotics officer, and he pointed, Phil asked him, he said, so where's the defendant? And he pointed at the birth certificate that was sitting on the table. And Phil went and picked it up. He said, this? He's like, yeah, that's the defendant. And no one objected. Now, of course, Brian was one of our friends, but it doesn't matter. The fact is that he said it, no one objected, and it went onto the record. So Great. We now have, and I think we might have been the first people, at least I know, that have ever done this, that we have on the record of the court that the defendant is the birth certificate. It's not the man. So anyway, nobody ever rebutted it. Nobody ever objected to it. So it's on the record. And I know it to be true anyway. So, but they're never going to agree to it. I mean, they're never going to admit to it. They have to agree because they'll default. But anyway, at all times mentioned herein, counter defendant state of Iowa was and is a corporation, obviously. I'm not going to read the rest of these facts, but you get the point. So then you get into what they did, or what the guy did at the time. So he pulled him over on a certain road, and it was a contractual agreement, but he was traveling, and so you get into the facts of right to travel. The acts of counter defendant at the time stated above constitute attempted kidnapping, coercion, false arrest, and trespass as per the law of the case. See the law of the case sections, right to travel and due process. There is no law, state, county, or city statute or ordinance that authorizes the issue of a traffic citation without there being any evidence to suspect being engaged in commerce on the roads and highways. See the law of the case, right? So anyway, you're getting out of the commerce thing. And the facts go on for a while, so I'm not going to read all of them. So then you get into the conclusion. Counter defendant, this idiot, has without lawful right trespassed upon the right of counter plaintiff, used color of law as an authority to deprive counter plaintiff of his right to use the roads and highways for private use, and has exceeded his jurisdiction as a duly sworn sheriff deputy under oath without cause and without lawful authority. The above actions and or omissions of the counter defendant were so grossly negligent as to amount to a deliberate indifference to and deprivation of counter plaintiff's substantive rights, which are at all times protected by the state constitution, as stated in the law of the case. And again, you guys can read this for fun. And the conclusion we have here is for the first cause. Okay, so I did the conclusion in the first cause, and this is the second count, trespass on the case. Now, this is how you transition from one action to another without having to rewrite the whole bloody thing. This is an action and claim of trespass and trespass in the case, counter plaintiff reaffirms and declares again paragraphs 1 through 46, right? All that stuff that was above it, and the same are included by reference in this count as though fully stated and set out herein. Now, he doesn't have to restate all these facts again in the second count. Okay, that's how you squish it. By right, counter plaintiff reasonably respects to proceed without injury, securing his capacities. Anyway, this trespass on the case is where there's a trespass, but it's not physical. Right, so he's trespassing on his estate, basically, is what we were saying in here. So you just state that he's legal duty to do such and such. You add a few more facts, whatever it has to deal with as far as what they're dealing with. Actually, this is kind of funny, so I guess I'll read this. On October 5th in the year 2017, counter plaintiff asked the judge of the Iowa District Court for Lee County, Gary R. Noman, in open court, I would like to ask your honor which jurisdiction we're in, to which Gary R. Noman gave a non-answer and said, you are in the Iowa District Court, in and for Lee County, and in the state of Iowa. To which the counter plaintiff stated and asked again, to know what the jurisdiction of the court is by stating, okay, which of the 4 jurisdictions would that be? Now, it's technically 5, but of course, obviously, he wasn't in the military, so you can throw out military. To which Gary R. Noman again refused to answer the counter plaintiff, thereby denying the counter plaintiff the nature and cause of the charges. Right? So once the judge doesn't answer those questions, he's trespassed upon your substantive right to know the nature and cause of the charges. You have the right under every single constitution to know the nature and cause of the charges against you. The second that they deny you that right, that's a trespass. I don't know why the hell I'm here. You're not telling me while I'm here. So why am I here? Right? That's a trespass. Thereby the actions of Gary R. Norman as a judge and officer of the court exceeded his jurisdiction as a judge, and that of the inferior court denied the counter plaintiff a substantive right protected by the 6th Amendment of the Bill of Rights, and therefore committed a trespass upon the substantive rights of counter plaintiff by denying him the knowledge of the nature and cause of the charges, whereby rendering this court as non-existent and without jurisdiction of the counter plaintiff. See the law of the case, blah, 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 yada, yada. So anyway, and we slap him with a few other things about nature to appear and the estate. We tell him what the estate is. The whole thing about the estate, right? Mailed to the estate of Philippine, and notice of failure to appear, enter a plea or pay fine. So they sent him notice to do this, or plea or pay a fine, before there was anything even filed in the court case, which I thought was hilarious. But anyway, so anyway, you guys can read this about how to write it. Read the fun stuff of how I wrote it, and you can get an idea of how Phil's case was like. And then count 3, action on a sunset. This is basically stating that I don't owe you anything. Basically what we did was we took the ticket and we rescinded the signature and then sent it back to the sheriff's deputy within 3 days, which is why it's a non-assumpsit, because we're saying, look, if you're going to base traffic ticket, the signed traffic ticket, as a lawful contract, then you don't have a contract. So screw you, basically. So then, yeah, and then the damages are all a result of the injuries, the pledge, we know how to pledge, conclusion, and then you do the conclusion. And then notice of default, so counter defendants have 30 days from service process to answer counter plaintiff and all actions herein, or the court will rule in their favor, yada, yada, yada. Verification, so on and so forth, signed, sealed, delivered, right? Done. So there's your template for a court of record action against a cop for a simple traffic ticket. Let's look at the DNC lawsuit. Now, this was the one, if you guys remember, this was the stink that the Democratic National Committee filed against versus all kinds of. This is the suit for the Russian bullshit. This is the suit, okay? So if you guys ever wanted to see it, here it is. So the Democratic National Committee with their, BS Russian spying thing. So they're the plaintiff versus against the Russian Federation, General Staff of the Armed Forces of Russia Federation, operating GRU operating user pseudonym Guccifer, who wasn't, this guy didn't have anything to do with Russia. Some other people, WikiLeaks, Julian Assange, President Trump Jr., Paul Manafort, Roger Stone, and all these other people, right? And then Doe's 1 through 10. Okay, so that's who it is, or it's against. Jury demanded complaint, computer fraud and abuse, RICO conspiracy. Notice these are all under USC, right? Stored communications, also USC. All this USC until you get down here. Trespass, DC common law, huh? Right? Take notice of that. DC has common law. That says DC common law. Tell them you can't bring it. So anyway, I saw this and I was like, whoa. I never thought you could do that. I didn't think you could run common law through DC, but apparently you can. Because these attorneys are some of the highest paid attorneys in the world, and they're not going to screw this thing up, okay? So anyway, trespass to chattels, Virginia common law. Conspiracy to commit trespass to chattels, Virginia common law. So you can't, if anybody wants to tell you that there is no common law or you can't bring a common law suit, just throw this in their face. So anyway, now this, the way they do these, now this is 66 pages, so it's long, but it's not ridiculously long. You do a table of contents, which if you got a really long suit, fine, do a table of contents. If not, don't worry about it. So the nature of the action, introduction, overview of the conspiracy, damage to the DNC, jurisdiction of venue, parties, general allegations, and then Trump and Trump's associates, pre-existing relationship with Russia, and Russia oligarchs provided fertile ground for Russia-Trump conspiracy. So let's blow a bunch of smoke up everybody's ass and pretend like something happened, right? Conspiracy to disseminate stolen DNC data to aid Trump. Anyway, so you go into it, and this is like they're trying to tell a story. So this is where you're talking about the facts, forensic evidence, this, that, next thing. So they're telling facts. Table of contents continued, so they're still telling their facts. Defendants' repeated efforts to cover up contacts. Again, that's like nothing. I don't even know why they're bringing that in there. Significant harm inflicted on plaintiff. That would be, and then finally you get your cause of action. All this blah blah whatever crap, general allegations, is just them bitching. Cause of action. This is where the information is, the meat of actually what they're trying to sue them for. So what? Count 1, count 2, count 3, count 4, count 5, count 6, count 7, count 8, count 9. So you get all the way down here, right? So you go through all your counts, then what? Prayer for relief. But these, page 50, let's go have some fun. Let's see what these high-paid attorneys do for common lawsuits. Conspiracy to commit trespass to chattels. Virginia common law against all defendants. Plaintiff realleges and incorporates by reference all prior paragraphs of this complaint and paragraphs in the counts below as though fully set forth herein. See? That sounds familiar? That's how you squish it. Defendants were part of a common scheme in which they conspired and combined to access without authorization the DNC's computer systems to steal confidential information, publicity, disseminate the stolen information, and use that stolen and publicity disclosed information for the common purpose of denigrating Secretary Clinton and the Democratic Party. Denigrating. Oh, God. Anyway. And bolstering Trump's electoral prospects. These actions consisted an exercise of wrongful dominion over plaintiff's computers and computer system and private email accounts. The word dominion is important because it's an aspect of common law. When you have absolute control over something at common law, that's your dominion. Pursuant to and in furtherance of this common scheme, defendants conspired to commit the unlawful acts described herein. So pursuant, name of defendants, aided, blah, blah, blah. And what they're doing is they've already have all the facts up above. All they have to do is just state why it's a common law action. This is violation of Virginia computer crimes. This is by statute again. So not common law. I thought they had two common law ones. Anyway, and there's the prayer for relief, same as what we did before. So wherefore plaintiff demands judgment against defendants on all counts and seeks such relief specified, yada, yada. There's your thing. And then jury demand, right? So looks the same, but you got to change it. If you want to do it at law, then just make it look at law instead of making it look like it's an equity suit, which is what that would have been. Okay, so we've gone through that. Lawsuit, law of the case, did. 7 parts declaration, did. Common law actions, did. Defendant, you guys can look at that yourself. That's just the common law defenses handout. And then what is Treatise? This is from Wikipedia, but whatever, it's not completely off. In law, Treatise pronounced, I completely butchered that. Sartius? I'm still screwing up, I'm sure. Latin for position or site of property is where the property is treated as being located for legal purposes. This may be important when determining which laws apply to the property, since the situs of an object, I'm just going to keep saying situs, of an object determines the lex situs, that is, the law applicable to the jurisdiction where the object is located. This is an aspect of venue. This is also what you mean by venue. If they don't have venue, they don't have anything. Meaning, you can't charge me for a crime under French law when I wasn't in France. Capiche? Or in Italy for that matter. But what they do is exactly that. They charge you for federal law when you're not in DC over this, or from this federal overlay that happened with the Buck Act. And that's why everybody has zip codes. If you're using a zip code to have something posted to you, you are considered to be in a federal area. Don't know if you knew that or not, but you better pay attention to it. So either put the zip code in brackets, and or also you could put the zip code in brackets, and after the zip code put -9998. Don't put the 4-digit thing of whatever they want you to put in there. Put 9998. What that means is without the United States. And technically, in a weird way, that's supposed to be the same thing that the post office uses. But again, when the post office before it was taken over by a corporation, it was technically outside the United States as well, because it was the de jure way to send post, right? So anyway, I'm going to skip down here. The situs of real estate land is where it is located. The situs of a chattel, tangible movable item, is where it is currently located. The situs of a bearer instrument is where the document is located, meaning like a bank or a trust company. But the situs of a registered instrument is where the register is held, meaning, so the situs of your doc set is whatever county recorder you filed it in, right? So that's basically what that means. The situs of debts is where the debtor resides, since that is generally where legal action can be taken to enforce the debt. The situs of intangible property, including intellectual property and goodwill, is where the property is registered. Or if not registered, where the rights of the property can be enforced. Now that's a huge difference, but anyway, the point is, so where's the property registered? Okay, if you're registered, your body is registered in your birth county. So, like I said, it's not an imperative, but if you can't get your doc set filed in your birth county, just file it someplace else, file wherever you can get it filed. I don't care. But then I would get a certified copy of your doc set and then just take it down to and put it as a notice into your birth county record. Okay. Just because of this little reason. The situs of a ship within territorial waters is where it is located, but the situs of a ship in international waters is its port of registry. Isn't that a funny thing? If you're in territorial waters of the United States of America, that's where the ship's located. But once you're out into international waters, it's where its port of registry is. So all of a sudden it just disappears. But anyway, so that's an aspect of citizen understanding of the where. And if they don't have the where, they've got nothing. So yeah, to finish up here, the last bit, as far as how to shut down each court, I actually went over that already. There's the thing about contract. I pulled that from Bouvier, so you guys can look at that, understand contract. The rules of federal civil procedure are in here, so you guys can look them over. When all crimes are commercial, this is a little document created by somebody else that shows and just proves the fact that they're running everything through commercial courts. Yeah. And this is, according to the late Chief Justice William H. Rehnquist, 100% of the people that are in federal or state penitentiaries are there voluntarily. Yes, he said that. Yes, he's correct. So stop volunteering. But anyway, so that's an interesting thing to read. Kevin Hogan, The Psychology of Persuasion. I can't believe I actually found this book. This is a book I actually met this guy. I had a signed copy at one point. The reason I dropped this for everybody is that you got to understand how these judges use psychology to get you to do things. So this is The Psychology of Persuasion, How to Persuade Others to Your Way of Thinking. Honestly, just read it. The book absolutely opened my mind as to how easily people can be manipulated by language, by gestures, by sentence structure, by tone of voice. I'm not going to get into it, but it's a stunningly interesting read. I've never found it to be incorrect. I've used it and its practices and ways a lot of the times in my life. I don't use them for nefarious reasons, but I suppose one could, like the judges, which is why I brought it up. Because there's one thing in here when they get into the lists of the various different, he calls them the laws of persuasion. Anyway, I'm not going to look for it because I don't think I can search this. No, I can't. Anyway, I'll do the text recognition on it. I'll save it into the file. And so that's the class for today, guys. I mean, I know that I didn't cover a tremendous amount in specifics as to various different writings, but all of that, again, all of that is in everything that I gave you. And you want to start with the collected pleadings, and particularly traffic demur and the examples of how to plead various different things. If you want the templates for every other kind of motion and thing, just go into Cornforce pleading library and then base it off of that, but alter it to whatever it is you need. So that's all there. So you guys have that available to you, and you have what to say in court. And I didn't even cover this, but here are my templates for what to say in court, like when you first open up your court. So that's in here. And you guys want to get to doing your grand juries? Well, that's in there too. And the last thing I'll cover here is just how do you shut down each jurisdiction of law in the proper way, verbally, which is the handout. That's how Frank does it. This is how I do it. So in common law, where's the damaged party, Your Honor? Can the state be a damaged party? The answer is no. Why? Because it's incorporeal. You can't damage the fiction of law. Equity. Well, where's the contract, Your Honor? I have no contract with the corporate state. Yes, you do. You have a driver's license. Objection, Your Honor. Where was the lawful consideration exchanged? When you say this is a lawful contract, I put it like that probably. Or you just say no lawful consideration was exchanged between I and the state, Your Honor. How is the driver's license a lawful contract? That also works for a mortgage, by the way. And then maritime amnesty. I'm the owner of the vessel in question. Who brings claim under what contract? Because when you say and walk into court, when he says, state your name for the record, you say, I, John Henry, come before this court as having been found to be living and as the sole lawful executor and heir of John Henry Doe. Period. That's all you have to say. And then somebody else has got to prove otherwise. That's all that. Thank you very much for everybody for showing up today. I will, as always, make sure that the recordings are posted to everyone who paid for class, and make sure that they're also posted in the Vocational Science of Freedom Lifetime Members Room. With that, you guys can, as always, ask me questions anytime you want on Gilded. So with that, I thank everybody for showing up, and this has been the April 2021 all-day law class, the ins and out of court. And thank you guys tremendously for all your support. Thanks a lot. Have a good night, guys. Appreciate it.